permit was denied and why your variance was requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for this case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to question. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. Staff and then the applicant will be given an opportunity for rebuttal. Chairperson will then offer a motion and a second to approve the variance, and then the chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in close of deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. May remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, April 25th, and the board is considered at this hearing. If your case is not appealed to the Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel that there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it know before we start today's hearing. The board is acting again as a quasi-judicial capacity for purposes of this hearing and only accepts sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner, have not received a copy of that opinion, please discuss with the clerk and the documents provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with the North Carolina General Statute 160A-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. You will hear 6 cases today, 4 recommendation agenda items, 1 regular agenda item, and 1 historic district appeal item. First case is case number 2022-024, 2300 Shenandoah Avenue. Did I say that right? Shenandoah Avenue. All right. Lisa, you may approach the podium and I will swear you in as well as Shaq. All right. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yeah, I'll give you a minute to look over.
Please.
The property. Exhibit number 5 is back. The applicant obtained a permit for a garage. Property is a corner lot and has a 10-foot minimum street side yard along West Denver Street. Though that street side yard is typically 10 feet. The notes on the garage permit stated that the setback on West Denver was 20 feet. But the plot plan application shows the proposed setback. When the garage was finished earlier this year, the notice of violation was not compliant with the required 20 foot. Next is the variance request. Applicant requesting a 9-foot variance to the required 20-foot garage setback to allow an 11-foot setback off West Denver. Exhibit number 7 is consideration. Staff supports the requested variance. Hardship is not a result of actions taken by the applicant. The garage was constructed as indicated in the plot plan submitted with the permit. Applicant stated that the 20-foot setback was voted after the permit. Survey shows that the garage is 22 feet. Hardship results from conditions peculiar to the property. The lot was subdivided in 1913 prior to ordinance regulation. Sidewalk directly abuts the street, and there's 7 feet of sidewalk in the right. Private cost of use and permitting, but newer subdivisions have sidewalks that directly abut. Exhibit number 8 is considerations. The requested variance is not easy to detect. West Denver Street dead ends and right, granting the requested variance. If the driveway length is 18 feet from the back. At the end of my presentation.
Does the board have any questions? I have a question. So on this photo right here, where is the garage on? Right. If there are no questions for staff, Terry, do we have anybody here? That said, is there a motion to approve or not? So second.
I'll second.
Okay, there's been a motion to approve the variance by Mr. Floyd, second by Mr. Court. We will now go into a roll call vote. Mr. Floyd?
Yes.
Mr. Hamid?
Yes.
Mr. Dryden?
Dryden, yes.
Mr. Court?
Court, yes.
Wilson, yes. Now we're going to look at the finding facts and conclusions as well.
Make a motion to accept the finding facts and conclusions of law as written.
Second.
Second.
Motion, the finding, there's been a motion to approve the finding facts and, of law by Mrs. Dryden and second by Mr. Hamid. Now we'll go to a roll call vote. Mrs. Dryden?
Dryden, yes.
Mr. Hamid?
Yes.
Mr. Floyd?
Floyd, yes.
Mr. Ford?
Court, yes.
Wilson, yes. Our next case will be 2022-029. And this is represented by Colin Brown of Big Alexander Ricks LLC.
Our next case. Seat 65.
Okay, we see, we see.
Exhibit number 2. Property zone. Exhibit number 4. Exhibit number 5 is background. The site's been approved for multiple use and the construction of street and a multifamily portion of the site is currently under construction. The northern boundary abuts R5 single-family residential zoning. The code limits building height to 65 feet and 200 feet of single-family residential property. I'd like to begin construction on the office building on the property located 100 R5 property. Units are zoning requirements, maximum height. Within six, applicant is requesting a 75-foot variance from the 200-foot distance requirement. Permit the office building to exceed 65 feet. Number 7 is considerations. Staff supports the requested variance. The hardship was not caused by the applicant as a result of conditions of the property. The construction of Hillmont Avenue across from the trail portion increased the permitted development. Sugar Creek and property back. Restrict future single-family development closer to the office. So area in gray. The northern R5 property boundary is converted shape that causes it to be closer. A portion of the building, 200 R5 is in flood. And that requires a higher foundation to bring it up to base flood elevation. The variance is in character with the neighborhood height permitted structures in the C district. The intent of the ordinance separation requirement for residential zone is met because the property within 200 feet of the office building can't be developed due to little sugar. Exhibit number 1, photos and instructions. That's the end of my presentation.
That little, not that little, but the brown building, is that the warehouse that they are, my description? That's altered, but. That's, okay.
So, where's 200?
The first thing. To the north,
Is it red? Are there houses there?
Wouldn't be able to build in that deep easement, in that gray area.
So even though it's designated on Bay River, we can't build there. So what you're saying is it's kind of a moot point for them to ask to raise this because they're not going to be close to anything that's going to be built. So what's the land now? Is it just open space? Or is it-
It's open space, there, power. Trying to see a little space.
Is this, so this aerial is an aerial before Philmont Avenue was built, and did they change the, so I guess the property got, the top portion of the property got donated to the Little Sugar Creek Greenway there, so that's not the extent of the current property. Is it? Gotcha.
is the building that they want to build is in keeping with the height of construction? So- And what do they want to build on it? Is it an office building?
Are there any other questions from the board or staff? Terry, do you have any opposition to this?
No, Chair.
Okay,
Motion to approve the variance.
motion to approve the variance by Mr. Floyd, is there a second?
Court second?
Second by Mr. Ford. Now we're going to move into a roll call vote. Mr. Ford,
Court, yes?
Mr. Ryder,
Right, yes.
Mr. Lee,
Yes.
Mr. Floyd, votes yes. Finding of facts and conclusions of law. Is there a motion to approve the findings of facts and conclusions of law?
Make that motion, Dryden.
Motion to approve the finding of facts and conclusions of law was made by Ms. Dryden. Is there a second?
I need a second.
It's been a second by Mr. Amid. Now go to roll call vote. Mr. Amid,
Me, yes.
Mr. Floyd. Floyd, yes. Ms. Dryden,
Dryden, yes.
Mr. Ford.
Court, yes.
Wilson, yes. Case. Case number 2022-033.
Our next case is the applicant is requesting a variance to permit parking in the required 20-foot transition. Give you a minute to.
Okay, Lisa, you can see.
Exhibit number 2. Exhibit 4. The site has a 1950 area. That's classified as a class 3 major. There's an existing 35-foot right-of-way from the center line. For major arterials, the code requires proposed right of way of 40 feet. That's an additional 5 feet of right of way center line. The code requires a transitional setback of 20 feet. It's measured from the off-street parking and maneuvering area is not permitted in the proposed right of way or in transit. But that's any of that area and that's. The existing development on the site is not. As parking and right away. Exhibit number 6 is the variance request. The applicants are requesting a variance to allow vehicle parking in the setback. But not. Exhibit number 7 is consideration. Staff supports the request. The hardship wasn't caused by the applicants, results from property conditions. The site was developed in the 1950s and has parking and maneuvering space in the proposed right-of-way. The applicants initially were proposing a variance request that would have included an encroachment into the proposed right-of-way. They worked with staff on that request and were able to revise the plan and eliminate any encroachment in the proposed right-of-way. So now the applicants are just setback space. The applicants are taking advantage of the administrative parking reduction permitted by code so that they can ask for the least amount of encroachment possible into the transitional setback that will allow them to originate the site. Parking cannot be located to the right side or the rear of the property due to existing building and other property. There's only about 27 feet of depth in the existing building. That limits the parking and maneuvering area in front. Exhibit number 8 is considerations. Which meets the spirit and intent of the ordinance and bring the parking lot further in by moving it back out of the existing and proposed right of way. Charlotte Department of Transportation is object to the variance since it will not encroach into the proposed right of way. Granting the variance will not change the character of the area because the property is one more Tryon approach to that. The variance will not impact public safety. The new parking lot will be connected and better defined. One of 3 driveways will be eliminated. The increased drive aisle width will better accommodate an emergency vehicle, and there will be pedestrian connectivity, street and front. Exhibit number 9 is photos of property. You can see kind of the under parking spaces to the front. Pictures and the top shows the existing parking lot areas. That's it in my presentation.
Looking at this picture, so where is the green on the far right picture, the green grass, is that the blue setback that was on the previous pictures? The one that they're not going to encroach into, or is that what they're going to?
So, yeah, the sidewalk is in that, right?
And so you had mentioned, I think in the previous slide, that that parking could not happen on the right side of the building. Is that right? But I thought I saw an existing parking lot, maybe getting my right. I thought I saw like an existing parking lot there.
So this parking lot is
Okay.
and then this right side of the building just directly above the.
Yeah, I think the aerial view was long enough. Okay. Sorry. Are there any other questions for staff? Sarah, is anybody not wish to speak?
No, Chair.
Motion to approve the variance.
There's a motion to approve the variance by Mr. Floyd. Is there a second?
Right.
Second by Mr. Dryden. We now go to a roll call vote. Right?
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Mr. Levine,
Lee, yes.
Mr. Port,
Court, yes.
Wilson, yes. Now we're going to review the findings, facts, and conclusions of law.
Make a motion to accept the finding of facts and conclusions of law as written.
Motion to approve the findings, facts, and conclusions of law as written was made by Ms. Dryden. For a second.
Second.
Second by Mr. Levine. Now we will move to a roll call vote. Mr. Levine.
Lee, yes.
Mr. Floyd,
Floyd, yes.
Ms. Dryden,
Drive, yes.
Mr. Port,
Court, yes.
Wilson, yes. Our next case on the agenda is case number 2022-035. Represented by Eric Sprouse and Mr. David Murray.
Right of way. The applicant is requesting two variances of the garage. 175-foot proposed right. 3-foot variance along I-77.
Okay, please, can you see? God bless you.
Exhibit number 2 is the zone. Property is zoned I-1 light industrial. Exhibit number 4 is exhibit number 5 are the variance requests. The site is currently vacant, located with the front lot along West Fremont Avenue, a lot along I-77 right of way. Since the front and rear both abut public streets, they are both required a setback from the right of way. The existing right of way for I-77 is about 125 feet from the center line of 77. The required setback is 20 feet. I-77 is classified as a Class 1 freeway. Code requires a proposed right of way of 175 feet measured from the street center line. And a 20-foot transitional setback proposed right of way. No structures are permitted in the right of way or transitional setback. See where those are. Staff supports the requested variance. The hardship was not caused by the applicant by conditions of the property. The lot was subdivided in 1913 prior to the zoning ordinance requirements, and the depth of the lot was 100 feet. Anyway, prior to I-77, increased the depth of the lot from 95 feet to 71. When the proposed right-of-way and transitional setback are permitted building depth ranges from 0 to 5 feet. That's sufficient structure. Variance would allow a building depth of 31 to 55 feet. Property is also constrained by a sewer easement on the right side and a drainage ditch along the rear and left side. Exhibit 7 is consideration. Granting the variance will not alter the essential character Most of the surrounding property is vacant, and one property has not. Lot's not easy to see. But it's located past the front. West Tremont Avenue, and it's located near the road. Right here. Granting of the variant for Exhibit number 8. That's the end of my presentation.
Are there any questions for staff?
I'm just a little curious about, I guess the state of North Carolina owns the interstate and so the city of Charlotte has a ordinance that's separate that I'm just trying to figure out the property rights and who, would the intent of the right of way is to reserve that area for building an interstate through later? Is that? And the city, the North Carolina Department of Transportation has this right of way. The city just says you can't build in North Carolina, the North Carolina DOT's right of way. Okay,
Zoning ordinance, which is completely separate from it, CDOT's purview start. This section.
okay, so that's
This
this,
is just Charlotte City.
Okay.
It's just-
What do they want to build on this property?
They want to build
Like a two-car garage or one-car garage?
a commercial.
So it would be a business. There'll be enough room for the driveway for the garage. We did it. So the building is where the three cars are.
there's a lot of storm drainage there. Did the city build that storm drainage? Is that, looks like a big right of way in there for storm drainage on that property?
There are down to Mecklenburg. Kind of the whole.
Right.
So if we approve this, then they can't come back and it's commercial, so pretty much it would stay a garage or some kind of structure like that. Couldn't build a house on it.
Are there any other questions for staff? Terry, do we have anybody in opposition?
No, Chair.
Motion to approve variance.
Okay, this motion made to approve the variance from Mr. Floyd. Is there a second?
Court second?
It's been a second by Mr. Ford. Now we move into a roll call vote. Mr. Ford?
Court, yes.
Mrs. Ryder?
Right, yes.
Mr. Lee?
Me, yes.
Mr. Floyd?
Floyd, yes.
Wilson, yes. Now we're going to review the finding facts and conclusions of law. Motion has been made to approve the findings of facts and conclusions of law by Mr. Floyd. Is there a second?
Court second?
Second by Mr. Porter. Now we move to a roll call vote. Mr. Porter?
Court, yes.
Ms. Ryder?
Right, yes.
Mr. Mead,
Yes.
Mr. Floyd,
Floyd, yes.
Wilson, yes. Now we are moving to the regular agenda, if I'm not mistaken here. Our next case is 2022-030. Charles and Peyton Poston, represented by David Murray.
They submitted updated applicant signature forms and done it.
Okay.
Can I give you a minute?
Okay, Lisa, let me see.
Property is R5. Exhibit number 4. Five. The lot was subdivided in 1950. There was some confusion about the width of the lot. Survey Commission in 2016, and it showed the lot as 50. Property was permitted in 16 after the survey was finished. The builder based the home located in the survey showing 54. Greater than actual. Exhibit number 6 is background. The applicants wish to sell the home, and there was a survey commissioned in 2021 for the home sale. It shows the lot width as 50 feet. Also shows a right side yard encroachment. 5. This does allow an administrative deviation of up to 2 feet of encroachment for a yard. And that's if there's no neighbor opposition, it can just be approved administratively. But there was neighbor opposition to the request. So it does require a variance now according to the zoning. Exhibit number 7 is the variance request. Staff supports the requested variance. The applicants are requesting a 1.5-foot variance and required 5-foot side yard. Compliance of the existing home. This will permit a 3.5-foot side yard. Exhibit number 8 is considerations. Staff supports the requested variance. The hardship is not the result of by the applicant. 2016 survey here showing a 54-foot lot width less than the front side. The applicants were unaware of the when survey was commissioned for the sale of the home. Granting the variance won't alter the essential character of the neighborhood. Okay. It will allow the home to remain in its current location since the time it was constructed 6 years ago. Granting the variance is consistent with the spirit and intent of the zoning ordinance and qualifies for an administrative mediation. There's not opposition. Finally, there's no safety issues associated with it. Exhibit number 9 is photos. That's the end of my presentation. Applicant,
Before we move to the applicant, are there any questions for staff on the board?
So Lisa, if we were to deny the variance, the remedy here would be they'd have to chop off and put it out their house.
Do we know that, what's the total distance from the new house and the existing adjacent structure? Is that known?
But the house was permitted based on the original survey, which was incorrect. Wonder how they got that so much.
My mistakes. So we're clear on that. 50 feet is the correct width. Okay.
And I was looking through the application, when was the original survey done? How many years ago was it? 2016, okay.
Built the house based on that.
Yeah.
And then I guess now that they try to sell it, they wanted another survey.
Yes, they found it.
But the house has existed there since 2016 with this.
Any other questions for staff? And so this, Lisa, that concludes your presentation. Then we have the applicant here. And applicant, if you could, well, you're already doing it, approaching the table and just need to swear you in. And I'm sorry, what's your name again? Are you Charles?
Yes, sir.
Okay.
Charles Colston.
Charles Colston. Okay, if you could just for the court reporter, state your first name and last name and your address.
My first.
Yeah.
Charles Colston, 1507, Hidden Falls Road, Charlotte, North Carolina, 28206.
Okay, and if you, I have to swear you in. All right,
Just because I.
and, Mr. Colston, do you swear to tell the truth, the whole truth, and nothing but the truth, no matter him? And I always forget this, staff attorneys, do I have to swear Mr. Murray in, but I don't, right?
I always swear.
You swear, okay.
So I do swear to tell the truth.
Okay, all right, may proceed.
Members of the board, again, David Murray, Murray Law Firm here in Charlotte, representing the applicants, the Seagulls, and the Colstons. This is 18-inch variance, so 1.5 foot reduction. And as stated by Lisa previously, administrative mediation was applied for, was supported by staff. However, there was an objection, so that's why we're here. As you can see on this 2016 survey, it incorrectly showed the lot width of 54 feet. Mr. Colston reached out to the surveyor, and Mr. Colston, if you'd like to tell the board, the surveyor admitted that he made a mistake.
Correct. The surveyor actually even came back to the site, redid the survey, and then it went in full.
What the surveyor had found on the site previous is this marker over here, there was an old pipe. And that is where he measured his survey from. It's an old pipe that was in the ground and set on a stick. And so, again, we have a situation where we admitted that so. And unfortunately, because of that mistake, that set all this in motion. And so the 2016 survey, the survey was used to apply for building permits. The builder relied upon the survey to the exact measure, applied for the permits, and obtained the permits and started construction, and the house was complete in 2017. From that time, there have been no objections. Nobody had raised any questions about the location of this house until just out of normal due diligence, the Seagulls, who were purchasing the property, their broker recommended to obtain a survey. And so they obtained the survey, and the new survey showed it was 50 feet. So plat shows 50 feet. Again, Mr. Floyd, you asked the question if there was a dispute about the lot line. No, there's not. Everybody agrees now, as Mr. Colston said, it's 50 feet. However, because the survey was done in 2016 and the house was started construction in 2016 through 2017, we have a house that was built with the impression that there was 4 extra feet on this side of the house. And so fortunately, we're only 1.5 feet encroaching because it could have been worse if they would have built it right up against the 5-foot side lot line. So we have 1.5 feet of impacts on the side of the house, and it is heated space. The fence location is shown on the survey, and that fence was actually constructed by the builder in 2017 when the house was constructed. And the builder thought that that was the property line. And so the fence was on where they thought the property line was located. Mr. Colston, since that time, before closing, he actually paid to have that fence removed and placed on the proper property. So there's not an encroachment on that from the fence has been removed. And Mr. Colston, can you find that?
Yeah, we confirm that the fence has been removed and a new fence has been constructed on the property.
So, again, administrative deviation under the section of the ordinance, it specifically states that 2 feet is likely to be granted for a surveying error. So there's no dispute that there's a surveying error here. Again, there was an objection. As you members of the board know, I like to always review the various standards here. The board shall evaluate provisions of the zoning ordinance of all showing unnecessary hardship conditions doing the property did not result from actions taken by the property owner, such that public safety and security substantial justice is achieved. Obviously, we have a hardship here because without the variance, we have 1.5 feet of this house that was properly permitted, but is not legally conforming. That's in violation of the ordinance. So, and as you heard Mr. Carter say, could be subject to removal. And the variance is needed in accordance to allow the existing structure to its footprint. The hardship runs with the land here. It's not personal to that. It's related to the house. It's rare that I actually have a case that's directly at a point from the Court of Appeals. I believe some of the board members were here for the Willow Oak case and heard of this Turek case discussed before, but the Turek case is this exact situation where there was a surveying error and it went to the Court of Appeals, and the Court of Appeals said, look, if there is a sealed survey that everybody thinks is correct, they take the survey to the building department reviews it, issues a validly issued permit, and then an issue comes up later when a new survey is created, that provides a hardship as long as it's done in good faith. And so here, the surveyor admitted later on that made a mistake. There was nobody was doing anything improperly. This was all done in good faith. And so the current case stands for the support to grant a variance for a survey error. No self-created hardship. The applicants did not create this. It was created by, unfortunately, survey error. Secures public safety and substantial justice. Again, we're only talking about 18 inches here. It's only 1.5-foot variance, so it's not a substantial encroachment. Again, for the former owners and current owners, it would do substantial justice for them to resolve the encroachment. And then conformity with the neighborhood, this is a single family detached house. It's, again, only 1.5 feet. There were no complaints prior to the administrative deviation notice being mailed out. It had been invisible from the public street and existed at least starting in 2016 when the house was finished in 2017. And so there's no question about the type of use and its conformity. And so we've met the 4 standards here for granting the variance. Again, if you have any questions, we're happy to answer. Mr. Colston, just to confirm, you reviewed the PowerPoint and the application and my presentation for my testimony. And you confirm that you fully adopt everything that I've said here today and our presentations that you said.
Yes, I do.
Any questions, members of the board?
Are there any questions from the board for Mr. Murray? Thank you very much, Mr. Murray.
Thank you.
Next, who is here in opposition?
We have 2 residents here in opposition. First is Ms. Christy Patterson, and second is Ms. Ruby Vory.
Yeah. And do you have a presentation of this come up the swear you in? And just for the court record, can you state your first and last name? Do you swear to tell the truth, the whole truth, and nothing but the truth and nothing?
So just, if, like, Mr. Murray just said, I think it's a matter of opinion whether or not the hardship and 18 inches is relevant. or not. I feel 18 inches is relevant on being the neighbor. And I also am greatly concerned that the licensed surveyor was allowed to get away with such a huge error. And so I took this picture and it just basically shows where the current property line is and then how much of the house. And it is a 2-story house, so it's even a greater impact because it's 2 stories that's encroaching on the side. So really simply, again, back to the surveyor. I'm just shocked, again, that this got through the surveyor, the licensed contractor, and all the inspectors in town. Okay, I didn't think when I bought the property that I needed to go and inspect the survey of the house next door. And, just a simple search through the historical land records to the register of deeds. I mean, it's very obvious. It's a 400-foot city block. And they're all 50-foot lots. Not for myself, their lot, and on my own. And even when they bought the house, 4 or 5 years ago, the neighborhood has exploded. So every single inch of property is really precious. And my purchase of the property was as an investment because of the neighborhood. And I fully intend to either sell my lot to a builder or build on the lot myself. It's 50 feet. A foot and a half is a big deal. It's a big deal that they're encroaching on the property, and I 100% believe it's on my ability on where I can build on that house. And when we have I build my full setback, which is 5 feet off the property line, and I build the house that they build, a 2-foot, 2-story high house, we are on top of each other. You look around this neighborhood, I mean, there are $1 million plus homes all over going up. It hurts the look of the neighborhood. Our street in particular, it's a really important street as we come down 25th Street now. They just built the road that goes across the street to the light rail station, tons of new development. So, and out of all of this, they gained. I mean, the builder gained, they were able to overbuild on a lot. An extra 81 square feet of the house that they were able to build. He was able to profit off of that. The current owners who have made a huge profit since buying the land. I mean, again, this land value in this neighborhood is extremely valuable and is only going up. They were able to profit, on the sale of the square footage of their house. And now when I go to build my house, one, Terry, you said that absolutely I can build right up to my setback, okay? So if I build up to the setback, which doesn't include the overhang of the house, because the overhang of their house is, I guesstimate is on the property line or foot off the property line. So I build my overhang, there's gonna be 5.5 feet between the roof line. I guess that's not a safety issue. To me, that seems to be a safety issue. But again, the look of the neighborhood, it's not good. So, I'm the aggrieved party here. They've gained from this in multiple ways. And now I'm just, I'm not gonna say, yeah, it's okay. I want to be neighborly. I don't want to have caused a problem. There is a party responsible here, and it's the surveyor. And I think, I don't know what the zoning board did about it this time, but, and the other thing too, Mr. Murray said that there was a fence down the property line. There was not a fence down the property line. That's the front part of the house that he showed. So there's never been, other than this little fence, which is clearly on my property, there was never a fence down the front portion of the house. The back portion of the house, of their house, goes in, and that's not the problem. It's the 27 feet, 2-story portion of their house that, it's, I've been going all around the neighborhood trying to see, I don't know how often you guys grant variances in our neighborhood with this type of situation, but I haven't seen any other homes that are less than 10. So again, it's just hard for me to believe that in the whole process, nobody did a simple search to look up the historical records of this urban neighborhood, that it's 50. This is just to show, like, my lot, it's 50 foot. Again, the 4.5 foot mistake. It's hard to believe. What?
So question I have is, do you feel that the owner should just go with the original surveyor's, findings of, what was it, I think 54 feet? Okay, so, do you feel that, the house, that they should just stick with what the original result was from this, when the surveyor came out in 2016 and made that error?
No, that makes no sense to me. I spoke with a couple different surveyors, okay? How did that surveyor give a survey of 54 feet? That's just crazy. The surveyor didn't even do diligence to look up the historical plot records I'm a nurse, I'm a licensed nurse. If I made that kind of error, that's a life or death decision. And it's hard for me to believe too that a licensed contractor and the city inspectors didn't question that 54 feet. I guess nowhere in the process, when you're building a new home, does anyone check after the surveyor to make sure they didn't make a mistake? I don't know. It's just really hard to believe. And I think most importantly, again, I feel like I'm the party here, right? They built this house, overbuilt the house. too close to my lot. And now it just limits my ability to build on it. And there's no doubt if I go to sell the property, it devalues my property. Builder's not gonna want to come in knowing that the next door house is encroaching on the side. It no doubt devaluing. Now, do I want them to have to reconstruct and take a parking lot off their house? No, I mean, I don't, but I'm not just gonna say it doesn't matter. It absolutely matters, and it's my property that's being affected. I don't know what the solutions are. I mean,
Any questions?
I just have a general question, just kind of similar to that, maybe for staff, I mean, the county keeps records on the dimensions of lots and they have an accounting of how big this is. The surveyor is supposed to go in and double check and make sure that the county's surveying is correct. And so is there any kind of, do they flag, if there's a conflict between the city's records and the surveyor's records, is there anything in the process that flags that or?
No, I mean, staff would rely on any professional, it's like an engineer designing a bridge or a building. We rely on a seal signature. Just like
Right.
we would with the surveyor.
Right.
So I have a question about the fence.
well, there was never they never had fence in the front part of the lot, which is the critical issue. The front part of their house,
Same way they gave it, that fence is on their property.
there was never a fence there. So they moved the fence on the back part, which was on my property as well. But that's really not the issue. I mean, yeah, I'm grateful that they moved the fence, but the issue here is the value of the land, you know, and how it devalues my property and encumbers my ability to build to my full
I
potential.
have to object on the speculation on that.
No, it's correct.
So, and then, like, I will never have to be here again. I'm just saying that, so when I go to submit my plans and I build a full setback and we're less than 10 feet apart, our structures, there's going to be no issue. I mean, the neighbors aren't going to object and I have to come and get a variance for that. There's not a fire safety issue there. That's also part of my concern.
You'd be able to build to the 5-foot side yard requirement. My understanding, and I can't say this for sure, but my understanding of the building code is 3 feet from a property line is the building code separation for a structure, for instance.
So that doesn't count the overhang.
That's just the wall, exterior wall. Because we do have some neighborhoods that were developed. We don't have this provision anymore, but there was a tree ordinance provision years ago that allowed for, you get incentives if you did so much tree saving. And one of the incentives was to reduce the side yard from whatever required to 3 feet. I think that was the purpose of where that 3 feet came from. Well, we've done away with that, but that was standard at one time.
So, and then, how can we be sure this doesn't happen again? If this happens in our neighborhood with our 50-foot lots and these things happen, to me, this was just a gross error. I mean, it's a lot. It's an 8% error on the lot. Now it's like other homes in our neighborhood, it doesn't look good. So is there something that, I mean, I would think something should be in place, at least the inspectors, at least simply looks up at the historical plot to see that, wow, this survey is way off. And it'll be real obvious when I build my house. Yeah, and we're gonna be waving at each other between our bedroom windows.
Any other questions for, this case?
Just to reiterate the public safety portion of it, in the application, they're saying the variance, they're saying that the variance of the, secures the public safety and achieves substantial justice. As far as public safety, I mean, I guess staff has reviewed that and confirmed that her concerns about building code and the proximity of building code.
And so it'll go on record too, that, again, I shouldn't have a problem when I want to build my.
Correct. So our variance is not exceeding building code requirements for proximity to property. So as far as their property, they're safe. And then you just have to meet building code, and when you build your property, you'll be safe. Everybody will be safe. And
It's just really unfortunate. Letting in this room that didn't realize the how expensive property was already in this town. So, but, you know, it's hard.
I'll make a couple of quick comments before we, just, okay,
I was
yeah.
planning to, licensed architect. They have direct experience with a home nearby where I was living, they were 10 feet apart.
I would have to see one.
Ms. Patterson, you purchased your property in 2018.
Yes.
So that house was in existence.
Yes.
That's your. No, I know. You live next to this,
It's a second.
so you don't rent.
It's a second one.
Mr. Mayor, have any questions? All right, thank you very much. Terry, is,
Ms. Ruby Roy is here for
okay,
opposition.
all right.
This is my son.
So,
Please read.
press the button on the microphone there. Mrs. Ruby, just for the corporate recorder, can you please state your first name and last name and your address?
99. Coordination. 716.
Same, yeah, it's Luke. I think it's beautiful. Fix your name. Address 317 Lincoln Township. So I'll have to swear both of you at the same time. You can raise your right hand. Do you swear to tell the truth and the whole truth, nothing but the truth in the matter at hand?
Yes.
May proceed.
So I see this, no. And then I made a phone call. About this. So what did that have to do? It had to do with the whole thing. Because what was a house on my is now just a vacant lot house. So I literally, once I took over my mama's house, I had to tear it down. For different things that came from inspectors, whoever rides around with the truck in that area. It's like they put a whole vengeance on my mom's house to restore and get a family member in there to stay. Texas and everything. But this young lady over here about her property, I am totally. I would not want anything else to happen to what she would be dealing on the other side. What the person, what is the right side or the left side. I would not want them to be doing any traumatic things. And even if she stole still coming in, I would not want that person to have to be right back up here with the same yes if they also, so this, I mean, it's like, evidently, don't have enough to do all the inspections, check out the zone, and I can't even, one house kept it back, the other house kept it back. We have beautiful trees in that neighborhood. So that's my safety factor. Rest of this, these notifications come so late in the time. I mean, by the time I got mine, I'm like, so what am I supposed to say? How do I get in touch with this person? I mean, I'm standing on the side of the table. It would have been, I would have been standing in the center part of Charlotte and bringing down my house on the side of town. That's not where I'm at. A seven, I'm a person who just completed January this year. A seven passed through. So most of the time, anything that was going on with my mom's house, another family members had to take care of my son that's had to help. So my thing is, I'm worried about everything that she's worried about, not just if I'm almost 70, so if I'm gone, she's still, and as soon as she's gone, how much will this keep coming up? Not only in, but also in public. That's the real shock. This kid always has been. I seen from the report that's furnishing and having stuff to get shot. So it's a fight. And I understand this boy over here trying to help this man. But it's still a fight for what we own. We are paying taxes on it. I originally, my been worth no more than $50,000 that I was supposed to be paying taxes on. And it totally went, I mean, now, because there's no answer. They can't find the papers, they can't find the pictures, they can't find the person that they did have helping you, I mean, from the zoning company. They can't find him, nothing, no information, nothing about it at all. But what I got from my other neighbors, who did call me, all the people that called, all the people that still want to buy the property when it was at 50,000 and now just 50,000 and back the whole one is that it would have been valued more than had I been able to put my repairs on the house. The rest of it is that no, why is the person in zoning being the one that's just coming to say, okay, I'm gonna get this house to me because the person riding around in their truck inspecting is the person that told all this information to neighbors who finally called me. Oh, I'm gonna get that house towed down. So I paid, they got my mom's house towed down. Then I wanted to leave the step. Oh, no. The steps have got to be torn down. That makes no sense. I can't leave the step. I can't just leave the step so the family members, and I do have family members that's over there in that area, that can just come and just sit there on the steps and have them come home. Because the house is there. If fires catch up out there, anywhere out there, you know, it's gonna be crazy. I'm thinking about safety issues, I'm thinking about value, because now one person's bill, they house at $1 million, the next person taxes go up to $10 million in that area, because that's what they, so I'm paying outline, I'm paying. I'm a retired person from the biggest hospital that's in Charlotte. Carolina Memphis, Charlotte, Memorial Hospital. That's when I started working at 15. At 15, I started working at the hospital. That was the only job I had. 38 years as a patient advocate, as a person that started off in the kitchen and came down, having all my education here. So my thing is, I'm sorry for your loss, but it still comes up to your architect, it comes up to your builders. Everything should continue to be resurveyed and laid out. Because nobody came back to help me. I just had to get someone to help me. It's not, I was bad about it. I live with sons.
Case is more about due diligence period. All parts, from the builder, from the county inspectors, from the owner. It's everything. Just that house. Should be second time. Look at that. In my opinion, it's pretty much the standard in purchasing. Due diligence done. So yes, I will break this out. But it's like, this case, I think it's young. It's brand new. That just wasn't. Shouldn't be put together. Builder that I being. So maybe they give a little bit more leniency. Zoning, which zoning is, I think, just a second set of eyes. And they're not there to say, yeah, you're right or wrong, but you're wrong and you see that you're wrong. And they're just there to help out the builder, which builder. Okay. That's just like I said, your profit from building a home. They show them to keep this home and a larger home should have personal for that lot. And turn around and tell it to another unfortunate people who say, oh, man, something's wrong. They still bought the house. The business said something among them. So obviously, you report where they sit. The situation is if someone would call it again, it would be a fight today. Can't build this or change the design. It could have been happening just like erasing it. In any other situation when you find something out of the zone, they can tear it down. Which in my mom's case, she just began on what happened. She had a home sitting in a place. Dilapidated. So all that is important. In this case, this house isn't dilapidated. It's only the setback. People over the day, not want to get done. It's big to stay because with our eyes, we don't see it. There's no reason to go measuring someone's front yard, side yard, backyard, say this isn't in code. That's not a just being a neighbor walking around saying, hey, spoke to the gentleman more than once. What I'm saying. So being neighborly is something I think all of us in this room are trying to do. However, there's some people who that's what the case is. The builder gets something. Architect that may have drawn the right drawings, but we didn't have anyone to give us the right set. And now we have the correct set. And issues. But we have all of a sudden. So give them the variance, and then are you going to? This area of Charlotte needs to have the same setback to this. It's just going to be now from here on forward, based on case basis. Every single house on that street, in that neighborhood, gets the same opportunity to build. So they can get the same person on the side that happen. I think that's happening. Yeah. Everybody gets the same opportunity. I think it's the whole entire neighborhood, small setbacks. Evidently, it's a reason. Say some sort of. This lady put something on where her setback that's 8.5 feet between two homes. The next person on the opposite side put something on the backyard, which is another 3 feet. Storage unit. This man's or the other person's side. This is 1.5 feet. Some catch fire. It isn't. That's not. If you have moving fence, then moving something wrong. Moving fence, no one will the house.
everything else, and probably still going, shopping is own city. Our whole neighborhood is owned. So we talk to plumbers, we talking about them coming in, doing everything that they have to do. Your house is in house, then we're over there, making things that don't stay where they stay right now, downtown. Things, I lived in the center of Charlotte, Brooklyn, ever since I was a little girl, then moved to North Charlotte. Then moved out of North Charlotte, and we've been here, still being. And it's decided to go where we are now. Never showed that right there. Never showed it on the weekday, showed it on the weekend. It's like it's on the outside. There's going to be done, and it's not done by this person, that person, who's selling me the property to someone else. Who's going to do it? Who's going to come down here and say, oh, well, that's not the city, but city can always come in and take part in it. You can have a foot long, big net this in your front, and then wind up with something in those space from you to me. And that's what it winds up doing. It shall be down. So, oh, it's like what is on your function. How that gonna help the person? No, that person is living, that person's coming around, it's coming around, that is, so that we don't have to have these meetings. Speakers. I mean, it should put all of y'all to go out and say, I was not come back on the city. It's the last one that's going on everywhere. Anything can happen. You got people instead of planning up there forward on the other side of the town. Those houses sold together for you. Never told about the poor. I was going back before we would still be on here. No way you will sit here. He's 42, and that's how long we've been trying to fight for. How can you find something that's the beginning of shelter, the beginning of any long term town around us? You can't find it. So people say that, you know what, I'd like to become a help with shaping my house. When I'm in place, I mean, I would like to get help. It's feel like these. But now I'm to go back to here. I don't know if you don't keep the steps somewhere in the nice little place.
Thank you. This, excuse me. This is the board.
I have a few comments that don't speak specifically to finding of fact or hardship, but I feel like they speak a little bit to the original intent of the construction and some of your concerns about maximizing profit and the impacts of zoning on that. The house is 40 feet wide, I believe, based on the diagrams here. So if the original survey was correct, they really would not have been able to build a house any wider than 40 feet. So the wideness of the house, they have not really gained from that additional 1.5 feet on how much they were able to build. And the original builder didn't maximize one direction or the other. So he had 54 feet to build on, and he could have built out to within 5 feet of both sides of his, what he thought was correct, but he built within 6 feet of both sides. So he kind of centered it within 6 feet of both sides. So that kind of gives me an indication that that this original builder was working in good faith, that he had a correct survey and did his due diligence in that he did not, it was, kind kind of hedging his bets in case there was an error in the survey by centering it on the property and not trying to maximize it one way. Because if he had maximized it in one direction or the other and found that there was a surveying error, he would have been breaking a building code violation. He would have been closer than 3 feet on one side. So those facts and dimensions kind of give me the indication that the contractor worked in good faith and the developer was not trying to overreach on maximizing the amount of area on the property. Again, I don't know how that really speaks to the hardships that the current owner has. You know, I think it is unfortunate that the 50-foot wide width of the property, it was a known factor, and the survey conflicted in that, and that there should be a flag in the system that that flags everybody on that.
But if you're trying to put like, whatever you're gonna put behind it, it's gonna be. Parents is that over there. He has this up here, which gives him the opportunity to put in the back. But if this, a lot of these parents didn't, how much space can he put something on right side and south? Or there's a person coming in. We're talking foot. Like saying that tear something. She's saying the same thing. But when it comes to your insurance of your house, it's not so. So how much is your insurance? He steps in. So who's paying who for what? Digging on something that's connected to something the city owns or something.
Any other questions? Thank you, Mrs. Wu. And, yes, Mr. Miller, do you have any questions?
My objections. It's the material.
And I believe we have another one. All right, you make Thomas and, that one, that's finished. For the court reporter, you can state your first name and last name.
Name is Robert, last name.
All right, and you can please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth on the matter at hand?
First, and I test.
First, say what?
Say that I test. Religious matter.
Gotcha, okay. See, okay, all right. Thank you very much.
Just wanted to read, I'm registered architect. Have you ever heard of this man? To confess, it's been about 10 years since I've dealt with a zero kind of setback situation. Back in the time, 10 years ago, 5-foot critical thing. Building code, but I was doing this because if you moved any closer, then the wall had to be fine. So that may be a consideration, but again, it's been. Second thing is, I resided in Hawaii at one point, renting a, they call it the Ohana unit, which is sort of a mother-in-law suite kind of thing. Anyway, the house, one down from me, caught fire.
And Hawaii is sort of like this situation that with the 50-foot lots. The lots are so small that everyone builds right up to the limit. What happened was this one particular house caught fire and quickly spread to the other house, which was 10 feet away. And then within about 20 minutes, until the fire department got the fire under control with the second house, I almost lost all my possessions. So 1.5 feet makes a difference when you're talking about this kind of situation. The other thing I would bring up is what the previous testimony was about, or talk, was that, and I'm familiar with surveying errors too, having dealt with those before. But this is obviously a hardship to the current owner because the house is where it shouldn't be. But on the other hand, it shouldn't become a bonus to the same owner if the setback line is now moved from its 5 feet to 3.5 feet. Because the tendency of the town is to build right up to the limits. I mean, everyone in town is familiar with that. So I don't know if there's a way where what's happened can remain, but keep the setback at 5 feet so that in the future, the new owner of the property doesn't have a benefit from this surveying error, if you follow that reasoning. And that's it.
Staff, address that, is that, so this variance is a variance for the specific conditions of the structure. This is not a variance that says that they can build within this proximity to the property line forevermore, or what is the correct answer to that?
That could be something that could be clarified that in the decision letter. We can, and part of the finding of facts, that could be clarified that it's just for the existing structure. And if some reason that structure is removed, any new structure would have to comply with the or addition. That could be.
Yeah, we stipulate this is for the existing structure to remain. That's why we're here.
Right.
Structure to remain. This is not so that we can add on to the structure within a 1.5 feet farther than what the fire is.
That's correct.
Any other questions? Thank you very much, sir.
Members of the board, standards.
Yes.
Objections, speculation.
Terry, or anybody else?
No, Chair. No further opposition.
Okay. If not, this concludes the presentation of evidence. The board will now begin its deliberations. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. Now, I just read that for formality. I don't know if board members, if you feel like you have to take a break before we go into deliberations, or do you want deliberations?
Sorry.
Okay, so Ms. Dryden wants to take a break. So let's take a quick 5-minute break. I would ask that folks in here that have given testimony, please do not approach the board members because we're still kind of in meeting. Okay, so we'll resume at 10:45.
Okay.
The property got exchanged hands. Construction, they fight this. Construction. They probably got surveyed and constructed.
Well,
And I'm personally, even if they didn't have to do that, they may not have done it.
Yeah, they just say it in reference. We're buying the property outright on
Right.
12216. Page 122. That's where
Oh, no, yeah, please do.
separation stuff.
Right.
I got you.
That's all right. I can pick those up too. That's always a hot topic.
That is where the error was. He's responsible.
Yeah.
He should, his title, should have looked at his team. Another title research. He was at. He said, oh, wait a minute, this survey says 50, this survey says 54.
And that's what I understand.
Yes, it should have been these bands of 4 feet in order to get this problem. Because this is a new. This 54-foot line. In essence, he's got sold him on line that does not exist by law. It was never reported. It's 54 line. And see what you mean about center. You don't know that. It's, sold him something, so his title insurance. Just to get it and say, wait a minute, we insured this title. He insured it.
Right.
And now he's trying to sell it. He actually sold it. He don't sold it. He's at it.
Right.
Because the tax record shows.
Right. So their attorney. So their attorney is the time that, yeah, so. They're just now getting, they did it without a variance, then the title,
Yeah, so the title company and the attorney.
company should have picked that up before they sold the property. Not, I don't know if that's, maybe because the title can change, I mean, it's changing the outcome, sure. You can just.
Yeah.
But whether, you know, hey,
Yeah.
You'll tell him that.
Well, I would imagine do that. He should. Yeah.
Yeah. Yeah.
But yeah, there's several positions and, but it doesn't change the title insurance company. We still need that same spot where they become
Yeah.
hardships and whatnot.
Well, and what's funny is, there's a guy next to me who's Wisconsin. Just sort of not that offensive, older offensive. And says, oh, I'm not there. Let me go to the search. It's the other one to come in. Let's just have this. And then he also said, these buildings work things like these. Purpose is differently and says, oh, no, come back later and ask for the business right of permission. That's what I'm afraid might have happened here.
Yeah, you get a 54-foot survey, which you thought you had 50, and you just like, hey, I got another 4.
Let's roll. Yeah.
Well, and it's, I mean, I don't think it's the rest of it, the original flags are wrong, and the flag now, sometimes, and engine, a little bit. This is the, I mean, even though we're here, we're at 50.03. Yeah.
No.
But I think, I don't know, it's just how, it has anything to do with value, fact, or hardships or anything, it's just, it's a check and balance that didn't happen.
People get approval. That's in the sundown. How'd they get approval?
Thanks for showing up as much.
I can get filled in. Well, let's set up again. Good to meet you.
Eleven thirty.
Let's, I'm gonna get started, I can, but, yeah. All that.
Years. This house.
Yes, sir.
Right, it's this trigger. Back. Back, wait, street coming. I think I'm good to go.
Okay, thank you, everybody. As I mentioned before our break, we are now going into deliberations. Again, interested parties are not permitted to address the board during this personal portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote.
Mr. Wilson?
Yes.
I received an affidavit from the surveyor explaining, that it was a pipe that I'd like to submit into the record, but, I didn't receive it until just a minute ago.
Okay.
So can I make a motion? Can I ask for a motion to reopen to present this, affidavit to the board? I just want to make sure that we have, evidence of the basis.
Are we able to do that, and does it have to come to a vote to the board?
Yeah, the board can reopen at any time to ask questions during deliberation, and since you haven't entered into deliberation.
All right, but I don't have to do a roll call vote for that. Oh, okay,
No, you can.
okay,
Any objection?
no objection. Okay, so,
Wait.
can she do that? Can she ask a question? Okay. All right.
What's the relevancy of a piece of paper plan? I mean, we're, can you just,
Yeah. All right, there's no objections to us reopening. Mr. Murray, you can, present.
There have been a lot of questions about the surveyor, and so I had stated before that, the basis of the survey was that there was a pipe that had found, this is an affidavit from Jackie Duncan. If you flip to the next page, shows the sworn, notarized statement. But again, this is just confirming that the basis of his mistake was a pipe, if you go back to the previous page, was a pipe, an iron pipe that he reasonably believed marked the corner of the property and used that location of the pipe in preparing the survey. So I didn't want it to be speculation on my part as to the basis of what the mistake was. So this is his affidavit. And so I'm submitting that into the record. My last closing comment, there was a lot of discussion about Mr. Colson and my clients, the Siegels. And I just want to remind the board that buying property, even if they had knowledge that a variance was needed, under the 4 standards, buying property with knowledge that a variance is needed cannot be held against the applicants in this case. So, thank you.
Thank you very much. And I'm sorry about that. What's your question? You can come to the front here.
It's crazy. The surveyor would come back and say there's something. That's how it's surveys. That's how surveys are done. I'm sure that's not the case. I'm sure there's due diligence and that they're tightening. One, I'm sure I'll be checking the historical records with the neighborhood, which face, you know, I mean, this is not a country lot. We're in an urban and 400 square foot, you know, regular city lot. If he came and looked at that pipe and says that has the property line, this is certainty. Thank you.
Thank you very much. Okay, any other questions on the board before we move to deliberations? Okay. So again, that does conclude the presentation of evidence. The board will now begin its deliberations. And again, parties, you cannot address the board while we're in deliberation. All right, so who would like to go first? Anybody? Okay.
Yeah, this goes back to a narrow, your, in a survey, and, I think we had questions, regarding the placement of the building and, relative to what they thought was, the request for variance is really just to deal with that existing structure. To provide some relief to the existing homeowner, to not have to remove a foot and a half off of the property. It doesn't have a direct impact to the future building. So the word that's going to basically property owners. But maybe advise Patterson, when you go to build your property, to ensure that you're working with an architect that understands that separation, because if you build to your 5-foot setback, you're less than 10 feet. So just understanding what you may have been kind of limitation to. But then reviewing the findings of fact and the case, it speaks to the board requirements.
Okay. Mr. Floyd, do you have anything?
Yeah, I mean, I think a lot of times when people speak in opposition to actual questions, there are particular limitations that are on the board. And our goal is simply to decide that we're not 4 factors in that. And they are, we grant the variances. We don't grant the variances. Here, the 4 factors are that. Was there an error by this applicant, this property owner that created hardship? No. Regardless of why the survey made a mistake, regardless of whether something else, you know, that's not really relevant. What relevant is, did this applicant, the current owner, are they responsible? Here, I don't think that they are responsible. There's no testimony whatsoever that they had any involvement in this placement of this building that created one foot setback. I do think that this is unnecessary hardship, requiring them to tear down or reconstruct portions of their home to account for 18 inches. I think is an unnecessary hardship. And as far as, you know, this being consistent with the chairperson intent ordinance, we have this in going out, I mean, our ordinance has allows the district to be, so they can, and a lot of it is from you just without becoming affordable. There's some discussions about safety issues and things like that, and I've not heard any comment that this by some experts or else actually testify that this would create some safety issues by having an infrastructure. This was, it's been 6 years, I just think it requires squares to get down and put that in their house. Over 8 years. So,
Yeah. Mr. Ryder?
I have great empathy for neighbors. It's always difficult when we have variances that come before us. But I agree with Mr. Floyd, the intent that, and the parameters that we deal with have been met. I don't believe anyone in this room would be okay with telling this homeowner, we're so sorry, but you have to reconstruct your house because of a surveyor's mistake. I understand that, I mean, that the surveyor was inept, and I hope that on some level that there is some repercussion for this Jackie Duncan for this inability to properly survey property. And I understand not everybody agrees with zoning rules. But what I do hope is that, and I would like, I don't know if we need to put it in the conclusions of facts or to make sure that they understand that this only, what we're saying today only applies to this particular house and this particular piece of property, and we're not setting a precedent that says everybody can build off the property line and they're gonna get, we're gonna pat them on the back and say, well, we're sorry that you did that, but we're gonna okay it. Because I don't feel like that's appropriate. And, you know, I do appreciate Mr. Murray's case study that shows that the courts have upheld that, you know, if it's a surveying error up to 2 feet, that they can, you know, we can permit the variance. It's a very troubling issue. It comes before us a lot. Homeowners say, well, my architect said this, or my builder said that, or my builder submitted this property, these dimensions, and it wasn't right. And we don't find out until it's not the original property owner, it's the new buyer or the new property owner that discovers this and then has to deal with it. So it's an unfortunate problem. I have sympathy for the adjacent homeowners. Again, as long as we make sure that we are emphatic that this only applies to this single piece of property, and we're not setting a precedent for this neighborhood, that the next person who comes and says, oh, well, it was an error by the surveyor, and I need 2 feet, that we don't just automatically rubber stamp that. So with those things in mind, I will vote to approve this variance.
Mr. Ford?
I agree with a lot of the things that have been said thus far. I agree that the thresholds of hardship have been met. And I think that the point of the variance or the specifics of this portion of this house and the variance being limited to just the existing building or just the portions of the property that are not in compliance, that this variance should not carry to the property. It should just carry to the specifics of what was built, would be important if that's not already inherent in the variance that we're granting to that we may grant today, which I do support.
So I would say that staff was not in the wrong here. Applicant is not in the wrong, nor the neighbors. This is definitely an issue that is with the surveyor. You know, I read an article the other day that said that Charlotte Douglas Airport is number 5 in the nation, is one of the most biggest airports in the country. And our city is growing very, very fast. And when I look at this case, I am concerned that we have an error in a survey, in a survey that really messed up this house and probably the neighborhood. And I've seen cases like this come before us over and over again. There's these errors, and it does get a little frustrating, but I know that we are limited in what we can do. My concern, and Ms. Dryden addressed this, is I am concerned that, at least for myself, if I was to vote in favor of this, that this will set a precedent. I don't think there's anything that we can do to stop that by putting it in finding facts inclusive law. I could be wrong on that, but I am concerned about that getting rough for the city, that if we were to approve this variance again, and I understand what Mr. Floyd is saying, Mr. Floyd is correct on that, that it wouldn't stop anybody else from coming forward to us and then trying to get a variance approved based upon this case. That's my concern. So with that, I would vote to deny the variance. Any more questions from the board?
I'll just say, I do agree that we need to let it clear this respect. And Ms. Murray stipulated to us that if we approve this variance, it is only for the existing structure. Doesn't allow them to extend the footprint of the building anymore, do additions and things like that. And certainly they could, do an addition, but that addition needs to be within the 5 foot, not the 3.5.
All right. Any other comments, questions? Okay.
I'd speak to the precedent thing, setting a precedent. I mean, I feel like the danger in setting precedent is that if the precedent is violated enough over time, that it becomes difficult for a court or lawyers to defend that precedent because it's just been violated so many times. And I feel like this situation where we're in right now is sort of the world of the exception to the rule world. And so I feel like this body is in the administrative world. If there becomes a precedent within the administrative world, where these things are being approved on a regular basis, then that's the first step of this sets up the precedent. But I feel like when things have gone through that process and they finally get to us, this, hopefully not enough things come to us that they could be construed as a precedent. So hopefully the number of cases that are brought to us stays low, and that what we're doing is always the exception and never construed as a precedent. But
And I'd just like to say, I just want to make sure that when the time comes for these homeowners to sell this property, that the new homeowners that buy it understand that they can't just willy-nilly build onto this house because we granted this 1.5 foot variance. I don't know that we have the ability to do that, but that's my concern. It's not so much this owner, but they're going to eventually sell this house. And it's going to have all the paperwork. It's going to say that the variance was approved. And so that's the slippery slope that I'm concerned with, that we understand that going forward, the next person who owns this house doesn't say, oh, well, I thought this was the way it was going to go. And then we're sitting here again with another homeowner saying, I need another 1.5 inches because I want to build onto my house. So those are my concerns as we move forward with this.
in looking at the property, it's got that little triangular shape, so the coverage ratio might be kind of close to its max already. In a way that they may not be able to add on that much.
That's true. But that's only a hopeful thing on my part. There's nothing that we can put in writing that would guarantee that.
Well, I think we can certainly, please be wrong, we can approve the variance subject to the merge stipulation. It says that the variance applies as to the existing structure.
Right.
And
Then I would be, that would make me happy if we could stipulate that. As Mr. Murray has said that they would stipulate. And then it be recorded on the deed or whatever that says that this is, you cannot build onto this existing structure as it stands today.
Can we get, I mean, are we granting variance for the property to be classified, or are we granting this variance for a non-conforming structure as the
Well,
non-conforming?
we'll address that. If we ask a question for staff and deliberations, let's go back into
Yeah, you have to reopen.
reopen, so. Yeah, yeah, you can answer the question.
based on the request, it says requesting a 1.5 variance required 5-foot yard for compliance of an existing home. So that would be, that's the request that we're approving for compliance of the existing home.
Right.
Yeah, that seems to me that it's not for future development, it's for the existing.
Okay.
That's how I understand it.
And then I have no more comments.
Okay. You have no comment, you say one more comment.
I have no more.
Oh, you have no more comment. Okay, say one more comment. You guys are good? Okay. All right. Did you have a comment?
So I'll just direct it at Jill maybe. So we do have some additional language to make that clearer if you all would like to consider it for your findings of fact.
Does anybody think we need to add additional language to make it clear?
I think that would be just.
I would like to see it written in the conclusions of facts and somewhere that, to reiterate that this is indeed just with compliance for the existing home and that it does not change the plot, whatever 50-foot is.
All right, well, I'd say, what we can do is move out of deliberations, go on to vote on either to approve or deny the variance, and then we'll talk about finding facts and conclusions of law. Okay, so this ends our deliberations. Now we will move into a vote. Is there a motion to approve or deny the variance?
Motion to approve the variance subject to stipulations that will only apply.
Okay. Motion has been moved by not Mr. Murray, I'm sorry, Mr. Floyd, to approve the variance based upon stipulations, that this will only apply to this property. Existing home property structure, okay. Is there a second?
Second.
Okay, second by, Mr. Hamid. All right, we're gonna go to a roll call vote. Mr. Hamid? Mr. Floyd? Ms. Dryden?
Dryden, yes.
Mr. Court?
Yes.
Okay, Wilson, no. Okay, now we will move into finding facts and conclusions of law. The variance has been approved, and now we're moving to finding facts and conclusions of law. So where we're going to add that, is that going to be number 26 now? Make sure I'm looking at the right sheet right here. I'm sorry, I was looking at the wrong one.
You're finding it back to number 20.
Number 20, I'm sorry. Okay.
And you give the applicant. So that is part of your request.
Mhm.
So you can.
Right, as it's, it's constructed, I believe.
So that's the new number 20? Okay,
Just adding.
add into it, okay. Okay. All right, you have that, Joe? Oh.
and as only construction.
Yes,
Okay.
that's good. As long as we repeat everywhere and we're all clear that that's what the expectation of the board is.
Okay.
All right, with that in mind, then I vote to approve the finding of facts and conclusions of law as amended.
Okay. The motion to approve the finding of facts and conclusions of law as amended was made by Mrs. Dryden and seconded by Mr. Floyd. Now we will move into a roll call vote. Mr. Floyd,
Floyd, yes.
Mr. Hamid,
Yes.
Ms. Dryden,
Yes.
Mr. Court.
Yes.
Okay, Wilson, yes. So that concludes this case. So now the next agenda item we have is the Historic District Appeal. Terry, is there any additional materials that we have to hand out for this?
Yes, Chair.
There are, okay. Do we have anybody here in opposition or? what is-
Yes, Chair.
Okay.
Mr. Lesnick here, applicant.
I'm sorry,
Mr. Lesnick.
Mr. Leslie. Okay, you, okay, all right, great. And Mr. Powers is here. Good to see you again, Thomas.
Yes, I'll wait, Mr. Spencer.
Okay.
Be ready right now.
And are you, chief of you, okay, so, okay. All right, got it. Yes, yes, if you would like to, while Terry's handing out materials, if you'd like to raise a question, you can. For those of you who are here for previous materials, thank you very much.
See you down the road.
Well,
Yeah.
I might be.
Oh, for the building.
Yeah.
Yeah. Get out of the seat. Hey, check out. Yeah. That drinks it out, makes it around. Good time.
Pick up the comments.
How are you?
She is walking and pulling, slightly rushed too. Yeah, she holiday, so, yeah, she love it like that.
Oh, my gosh.
Okay. Yeah, she got full taller bed status, and
It is right there at a great angle where she pops up noise and she can even look at the TV, so we don't even try to go to the restaurant, we just turn on Disney and immediately sit there like. She's enjoying her life, so.
And that's the hard one, that. What's this?
It is.
Because I'm not. Or,
Yeah, it did.
Sorry, darling.
Thank you.
Take care of the back.
No, it goes through people and having a part, but it's so.
All right. Is everybody here that's supposed to be part of, this case?
Yes, Chester. All right.
I think we are. Terry, I didn't get that appeal,
Not yet.
not yet, okay.
No. Not yet.
Okay, Thomas, whatever you say.
So, quick question for, I guess I can't ask you because you're in this case, I have to ask you. Since I swore him in earlier, up this round again for this case? Because he's been sworn in, okay. All right. Okay, so just for the record, we are hearing case number 2019-061. This is an appeal, historic district appeal. This will be, I think, the first one this board has heard, if I'm not mistaken. So I'll ask for your patience as we try to move through this. This is the first time the board's ever heard a case like this. So if you see some delays along the way, please keep that in mind. So here today, we have Mr. Thomas Powers, Senior Assistant City Attorney for the City of Charlotte. And then, I forgot her name that quick.
Christy
Harper, and you're also with your.
Parks, and I'm the program manager for the historic district.
Okay, so just commission. Okay, all right, great. Parks. Okay, got it. Did you get that, Candy? Okay, all right, great. All right, so next would be, are you presenting first?
I'm presenting. I have a kind of a question of law or whatever, or procedure.
Okay.
There was a part of the brief that came out, I guess, last Tuesday that I read from Mr. Powers, I guess was the author. And basically the gist of it was that I didn't have standing because I couldn't prove that I was aggrieved and the case should be dismissed for that purpose.
Mhm.
And so if the ability basically to have more time to establish that I'm an aggrieved party would be of a benefit to me, then I understand that it's too late for me to ask for a continuance, but it's also my understanding by the rules of the Zoning Board of Adjustment that if the record is not submitted 21 days in advance, that would be an automatic 1 month extension.
Mhm.
And the reason I bring this up is the original record was submitted 22 days in advance of the March meeting. But the reason that the hearing got delayed a month is because once I received a copy of the record, it was missing some critical documents in there. And these documents were things that normally I don't think anyone would find in the record because they were actually, they were delivered the day of the particular meetings for the 8th, and they were made as exhibits. So they didn't make it into the original record. I found that they were missing, and I asked that these things be included in the record. Anyway, the addenda to the record didn't come out until, I believe, the signed copy was available on the 16th of April, signed copy on the 19th of April, which is clearly within that 21-day period. So if it's just a matter of if I would be able to correct things along that way in a month, and it's part of your procedures that it would be an automatic delay of a month, then I would ask you to consider that.
So I guess that question has to go to Ms. Sanchez-Myers, or to Mr. Powers. Yes, sir.
Let me just respond to the two issues that were brought forth. One was the standing issue. That is a aspect that is dictated by the North Carolina courts, including the North Carolina Court of Appeals and Supreme Court. I only articulate what the courts have indicated and expressed in regards to that standing aspect. Without getting into the merits of the case, our primary would be he has no ability whatsoever to challenge the aspects, issues, or even concerns of the HTC decision because of what the courts have stated as a barrier to this matter for standing purposes. Now to the second issue, which is the actual materials aspect.
We acknowledge that the amended information was received, I think early last week, it was provided to you around that time, about a week before the actual meeting. Those were a few pages in that regard, in regards to the entirety of the matter, which was over, I think, 300+ pages. At least from the HDC's perspective, we do not believe that those pages in its entirety merit a delay, because that information is not actually, from our perspective, in any way for the argument of the actual petitioner slash appellant in this situation. It only reaffirms actually our arguments about standing in that regard. Furthermore, I will also indicate that some previous discussions that the petitioner and I had are about documents which we have explained from the HDC perspective, we do not have those documents, so therefore a continued requesting document we do not have would not be actually beneficial for this hearing, simply because we've explained previously through numerous emails that those documents are not available. We've given explanations why those documents are not available, how the petitioner seeks to, again, ask for documents that we cannot provide, and give an explanation related to it. But again, the basis of a request for continuance, we would object to that, simply because we do not believe even with the continuance, we would have any kind of change in the result due to the actual original decision from the HCC in 2019 to present. This aspect of standing cannot be all of a sudden cured within a 30-day time period, because it has not been provided well beforehand.
Could I respond to that?
I'm sorry, can I ask a question? On the standing, is the evidence of standing, especially the evidence that someone has to be able to show where to have do they have to show the evidence at the underlying sea level, or does that standing have to be shown here?
I would definitely say to your second part of your question, it has to be shown immediately here at this appeal. Now, whether they show it at the HDC level, it depends. It would be good to have that information readily available at the HDC, but for any review of the HDC's decision to the ZBA and the ZBA's decision to a Superior Court, they're immediately going to look at that question as the first question before we conduct the review.
I guess did the HDC make a finding that they're doing that this gentleman has standing?
No, sir. They do not make that determination at their hearing at all.
We have to make that determination.
You are obligated to make that determination, just like if a ZBA makes a decision in any of its cases, and that decision is appealed further, the presiding judge of the case is obligated to make the determination whether or not that party appealing has standing in order to challenge the merits of the underlying decision.
This position would be, I didn't know anything about this standing until I received the brief on the 19th of April.
Right, I probably need to add a little clarity how long this has been going on. There was a hearing on July 10th, was the last meeting of the HDC on this was on July 10th, 2019. I was on vacation at the time. I came back in later July, I believe somewhere around July 22nd, 23rd. Found out from a neighbor that the thing had been approved, quickly contacted Christie, how do I appeal this? And then what happened was I was told that the 30-day window did not happen at the COA. When the COA was issued, I was told that it actually happens when the verbal approval was given, which would have been July 10th. So I am frantically scrambling at the last minute to file an appeal. Now, it turned out that that was wrong, that the 30-day window happens when the COA was issued, which was in December of 2019 instead of August. So this gets kind of muddy. And so I scrambled as fast as I could to get the application in. I submitted the application on August 9th within the 30-day window to get it in. And I had a preliminary hearing with the city attorney, Andrea Leslie Fight, on the 16th of August to go over the procedures and everything. Now, as I understand it, because it's called, I think now a pre-hearing or something, that the point of this is to look at your application before you actually submit it, to make sure it's okay, is what I'm assuming. So I had no reason at all to think for all this time period, dating back from the summer of 2019 till Tuesday of April, this last Tuesday, that there was anything wrong with my application. I mean, the only thing that I changed in the application that's referred to in the brief is the date, because what happened was, because I had to submit my application, was told I had to submit my application, before the COA documents came out, I wrote my appeal based on the information at hand. And what came out was, and I asked for, was, can I revise my application once I see the COA documents, which would be my normal right. So when I looked at COA documents, there's a lot more measurements and data and whatever in there. So I took my original application, and where there's more information, simply like when it comes up when we're talking about pervious versus impervious percentages, since there's more measurements, I could get more refined in my revised application, which I did. Again, once I submitted that, again, no hearing again. I had my preliminary hearing. The application was judged to be fine. And, here we go 2.5 years later, and in the brief, it's saying, well, the petitioner had 28 months and he should have corrected in 28 months. Well, how in the world will I possibly be able to correct in 28 months when I knew there was no flaw, when I assumed there was no flaw in it? And then on top of that, the brief on Tuesday says, well, the time period to correct that ended at 4 o'clock in the afternoon on Tuesday when the brief was submitted. Well, I didn't even receive the thing until 6 o'clock that night, or 5:23, I think is when it came in my email box. So there's no time to respond at all. So, is the attorney for the HDC saying, we win by default? I mean, it's ludicrous. So because the complete record was not submitted in time, that affords me another month to get some experts in to do this. I would ask that you follow your own procedures and delay. The other thing I'd like to add is that there are two things that I think I established agreement on that are already in the record, including one of them is already in my application. And specifically in my application, talking about trees, it refers to a survey that I had done I believe in August or September 2019. That is a more refined survey than what the applicant provided.
I will be objecting to some of the information that the applicant, the petitioner wanted to submit to this board, because again, even though he has the actual presentation, some of this information was not before the HDC, it cannot be considered by this board. So I will note, based on the survey he's referencing, it was not before the HDC, so we will object to that remotely being included by this board for consideration.
I mean, it is mentioned specifically who did it and when they did it, and I have a copy of it with me.
Yes.
We have a basis to determine the state issue, whether he needs additional time, he needs additional time, put on some evidence that he would accept special as a result of this approval.
So the HCC perspective, staff, meaning the ZBA staff, was not under any obligation under the state law or even from a legal standpoint to provide that information to the actual petitioner/appellant. The necessary aspect of showing standing through special damages. Ignorance of the law is not an excuse in this instance. The petitioner was obligated by the state law to actually have that actually shown before I even provided that information by the actual memorandum.
Now,
Is there anything in this application that's filled out that says you need to identify what your special damages are so that we know that you, so these can establish your basis? Or is he just, at this point in time, we're at the hearing, now we put on the evidence, or is there, you should have tracked something with this application to demonstrate some allocation of your special damages?
I would say that, let me just use a modified hypothetical to your question. If this were to be at a court of law, the filing of the actual materials by a judge would have looked at what he filed, not necessarily the form that he filed. The judge would look exactly at the materials presented and made a determination based on his filing and information as to whether or not it would have been standing. If you've taken the exact same paper and taken it to a court of law, I would have the same exact argument, and the judge could have made the decision right then and there that he did not have standing, irrespective of his request now to supplement his application, not the record, his application with new expert information. The record as submitted is complete. He's asking to supplement his application with third-party expert testimony to show that he's been injured, distinctly different from everyone else in the community. I would definitely say, at least from the way we're arguing in the court, his expert testimony is not going to be at play, only because the actual property in question that he lives in is an apartment building. So again, it would be a situation, his apartment unit would have the same impacts as everyone else in the building. It's not a distinct injury under the court of law and the determination has standing purposes. Sure.
But versus, does he have the right to present evidence of special damages at this hearing?
He, to your question, does have the right. He is obligated to present that. What I'm saying today and prior to the application being filed and today, he has not actually gathered that information. So his request to continue it to me is not appropriate because they extended a month, 2 months, it's going to get us back to the same point.
Again, how would I know this? Ignorance of the law. I went in front of a city attorney for this city, and they had my application complete for a week. And we had a preliminary hearing. They said nothing. Now, if a city attorney doesn't have the capability to know whether the application is complete, what's the point of having a preliminary meeting? To hold this against me at this point after 2.5 years and say, surprise, surprise, your time is up, is absurd. If I can't rely on a city attorney to know whether an application is complete, what in the world can I rely on?
I would just indicate that from an ethical standpoint, the city attorney would never review whether or not his application met the legal threshold, because that would have been a violation of ethical duty, being that the city attorney is employed by the city and is paid by the city. His obligation would have been to get his own attorney to have that reviewed. The attorney would have actually reviewed it to see whether or not it's been properly filled out. But whether or not there's a standing question, the attorney could not have given them legal advice that you need to get this information or you should do that. So I would caution the aspect of relying on the city attorney failing to get that information is not a basis in that regard, only because as you can see from this hearing, there's a city attorney providing legal advice to the board, separate than myself, providing legal advice to the HTC and HTC administrator. So again, in this instance, I understand the applicant and petitioner's concern in this regard, but in this situation, the onus was on them to get their own attorney to navigate those legal issues. Okay, I think we're getting a little bit off track here. Ms. Sanchez-Myers, is the board allowed to do some deliberations so we can discuss whether or not we can continue this? Because
Sure. I would like to point out, well, first of all, it sounds like there are two issues. One, perhaps with the record on appeal not being submitted 21 days, and then also addressing the issue of standing, which the board may be able to consider those separately, or but as to the record on appeal, I did want to note to the board that our rules of procedure do state that the record on appeal of the City of Charlotte Historic District Commission must be submitted to the board at least 21 days before the scheduled meeting, counting the day of the board meeting as the 21st day. Any record on appeal received less than 21 days prior to the scheduled board meeting shall be placed on the agenda for the next meeting. in that regard, as to the substance of, as to reviewing the substance of the appeal, the record on appeal, hearing, reviewing that record for any errors. I do believe that, your rules say shall be placed. That language is mandatory as opposed to permissive. With the second issue regarding standing, Mr. Powers, I believe, has raised that as a separate issue. Again, the record on appeal is to allow that to, I believe the intent of the rule was to allow all the parties at least 21 days before the hearing to review the complete record, to allow all the board members to review the complete record so that you're able to determine, in the hearing, everyone is prepared to determine if there are any errors. The issue of standing is a preliminary, is a prerequisite before the board even gets to the substantive portion. So I believe the board could consider the issue of standing today as a preliminary issue, but
Mr. Lesnick is saying that he did not have enough time to, if I'm hearing you correctly, did not have enough time to prepare adequately for this because he didn't get the information until you said what, yesterday?
Yeah, and there was emails. First of all, I guess I should have read every word in everything that came, because the only reason I knew Mr. Powers was the lawyer for representing the HDC was at the bottom of a transmittal at the bottom of all the text there. Because I had repeated communications with Mr. Powers and he never disclosed that he was the attorney representing the HDC. So there's certain things that I said in there thinking that he's representing you, her role, including things like, I'm not as young as I used to be. If I get this information too late, I can't pull all-nighters like I used to. I mean, I'm just too old to do it anymore. I'm 66 years old. So this is kind of information I would never have disclosed if I'd known he was representing the defense in this thing. I thought he was representing you.
Mr. Powers. Yes.
Let me just say that the HST is not going to stick hard and fast to the standing issue. If you're wanting to move forward, at least allow him to have this time to present his information in regards to the merits, we can reserve that issue to the end. From my perspective, I think that's still an open question, but I don't want to get hung up on this today as being the threshold to even allowing have this being heard. If you want to go ahead and allow for his presentation of all the materials and our response, we can reserve the standing question as well as our overall position that if you wish to move past standing, the merits are still in our favor for an actual firm affirmation of the HCC decision. So I throw that out there as a way to move this forward if you so choose.
He's saying I didn't get my 21 days or whatever it is on the full record.
Well, I mean,
We waived his submittal because his submittal was also not necessarily at a timely manner. We waived that because he was trying to work on that and given how long it is, we're allowing him to move forward without really timely aspect having discussions with him as well. Only because he's wanting to make sure we have that submission here at the last moment as well. So I would at least say from the HCC's perspective that we try to work with him in the confines of the time aspect to give him every benefit of the doubt for his presentation. But the documents in question, again, we believe are not as detrimental as he alludes to, and given the extensive PowerPoint presentation that he has right now out loud in front of you, which is upwards of 200 plus pages, I think he had more than enough to present an actual basis to you for a reversal in that regard if he wants to go through it today. We still reserve the right to object to some new material that was not presented to the HCC and not part of this decision. But we leave that to your discretion.
All right, so I think we need to, as a board, go into deliberation if we are allowed to do that, to discuss. Because like I said, there's two options. There's two issues here, standing and whether or not if we would allow Mr. Lesnick more time to prepare for this. Am I correct? Those are the two issues that we're facing here. So,
That's my understanding of the issues. Because I believe Mr. Powers in his brief asked not the court, sorry, the board to dismiss, sorry, I don't have your brief, the appeal based on the lack of standing. But
And so my concern there is, does he have the opportunity to present evidence that gets him over that standing threshold?
that's
Where
my,
he was essentially foreclosed at this point because it wasn't submitted with his application. That's one issue. The second issue is, was the record on appeal submitted in, meet the statutory and our ordinance requirements so that we can move forward today, or are we obligated under our ordinance to continue it until the next hearing date?
that's what that,
issue number two.
yeah, that's what I'm.
If we, if the answer is yes, under the ordinance, we're obligated to continue this, I don't think we even have to get to the first issue at this point.
Yeah. So that's what I'm hearing. I mean, I'm hearing what you're hearing, Mr. Floyd, but I just want to hear from the other board before we, go for all this. Do we, I guess the question is, do we want to allow him time to get to that threshold? If I'm hearing that correctly.
Yeah, I think it'd be a good time to just kind of talk through what everybody understands, make sure everybody understands their own.
I mean, let me be clear on this. I mean, as was elaborated, I mean, the 21-day thing, I think, is more for your benefit, than I have to say, when I received the full record, or what I thought was the full record, my hearing that was scheduled for January that was delayed a couple of weeks before because of Omicron. I never even got into the March meeting, and I knew it wouldn't happen in February, and I never even got wind of it until literally I go out to my mailbox and there is a big package sitting on the floor, and it's come from the city attorney, I guess, and it's got my hard copy of the transcript, of the record. And then I contacted ZBA staff and said, am I scheduled for the March meeting? Because this is only a couple of weeks in advance. And he said, oh yeah, you're scheduled for March. So I never even had the 21 days that would normally be afforded me on this. But I scrambled, I looked it through, I said, yeah, I'm familiar with this because I'm pretty familiar with all this. I've seen all these documents, with the exception of ones that just physically weren't available. They were, and I don't even know if this is a violation of HDC rules. I guess we can get into that later, but.
Yeah. I'm just gonna have to stop you right there. I just want to make sure that we're not, I hear what you're saying. I hear what Senior Assistant City Attorney is saying as well. I think what we need to discuss as a board is what we need to move on through this. And my question to you, Ms. Sanchez-Myers, is the correct Robert's rules, what you want to call it, do we move to deliberations to discuss whether or not we should move forward with this appeal, or give Mr. Lesnick more time to properly prepare for it?
Mr. Chair, I'll cut it off for you. HTC will be more than willing to consent to a continuance to avoid even having this issue. We'll bring it back next month for a hearing. If you believe this is an issue, I don't want to drag this out unnecessarily. We'll go ahead and consent to a continuance of this hearing for next month and raise all of our issues, including standing and any other aspects as well at next month's meeting.
I mean, from my point of view, I've been dealing with this for the better part of 3 years now.
Okay.
I'm retired now. I kind of like to get on with my life. I mean, I do long distance backpacking trips and things. When we move into this summer season, the idea, well, they're going to have a hearing next month or whatever. This is really messing up my life when you're 200 miles in the wilderness.
So my question, Mr. Lesnick, based upon what Mr. Powers said, will you be willing to come back? That would be next month, Terry?
Yes, sir.
And would you be prepared for this to appeal this? Would you have what information?
I am personally prepared to today, but if it means nothing because I have no standing, And so what I'm sort of asking for is, well, if by the rules, you would issue, you have to delay it. And legally, in that time period, I would have the ability to establish standing to your, sufficiency.
All right.
Then that is a benefit to me. If the standing issue is moot, that it's too late, I can't do anything to correct it at this point, then I would just ask to go ahead and proceed with it today, and we'll talk about the merits of the case versus an application error, because I've got plenty on that.
If you don't have standing, we're not going to get it.
Yeah. Standing.
And this is my concern from being sort of a citizen part of this. Is that I would really like the board to understand the merits of the case. Simply because I think it's a benefit to not only the HDC probably, but to all the citizens of Charlotte to know where things went wrong.
Well, Mr. Lesnick, I believe the board is leaning towards giving you time to prepare adequately for this appeal. The city attorney has even offered that as well. Hope I'm not putting words in your mouth, Mr. Powers. Yeah. So if you want to wait till May, we're going to allow you to do it. So I think that's where the board is. Am I right?
Is there talk?
Yeah, that's it. We want to talk through it first. Yeah.
That's where I'm at. We don't hear anything from them. How do we say when the HFC has said he doesn't say?
You might want to just designate the building right to you, here. If he can't, then there is no understanding, if he doesn't have that, he can be right to you.
I can offer, and I probably would need more, but I can offer in my presentation that to establish that I'm an aggrieved party that's beyond basically everyone in the district, that there was actually, as I understand the reading of the law, there was a misdemeanor criminal act committed by the applicant with the removal of trees, and I have a letter from the board.
Objection. That's not a basis for standing. That is not a. Let me just say that if you want to have a basis for standing, he needs to go get expert information from an expert. He can't offer his own hypothetical analysis of the situation. If the board is willing to allow him to prove that he has standing, the HDC we would like to object to that, but understanding right now the temperature of the board will at least consent to a postponement for him to go get a third party or multiple third parties to show how he's been injured. If he can't get that information, the law says if he can't show it, automatically the answer is he doesn't have standing, therefore he can't challenge it. If he does bring information, we would have the ability to actually not only question those individuals, but we would have the ability to refute how this is applicable or is only geared toward the entirety of the actual community, not just him. So I think the question, I'm not sure who asked that question, but to the actual standing aspect, he needs to bring in evidence. He can't bring in evidence, the question then defaults to he has no standing. If he brings in evidence, he's at least put forth that evidence. We have the ability to review, and then we can challenge whether that evidence is sufficient as part of your review. And then at that point, if you wish to reserve the question and proceed for the rest of the presentation, you could do that as well. But if you're going to offer continuance, I would say one point, which is there probably needs to be a small window, and I'm willing to even concede at this point that if you want to continue for here to go to a third party, I'm willing to accept at least 3 days beforehand, theoretically the Friday before, and try to come in here and have a presentation, give him close to 30 days. But because of your concerns and because he has alleged that he was woefully ignorant of the law and did not try to get an attorney at all in this process, I think that's the best I can do for him to try to show standing if he wants to get into the mix.
but that's just an offer that the HTC is bringing forth in this regard. Okay, so let's just go to deliberations. That's what I'm trying to get to. So let's go to deliberations to decide what to do. And as I mentioned earlier, in other cases during deliberations, both parties cannot address the board. All right, we are in deliberations. Okay. Yeah. So who wants to go first?
So one thing that I'm not 100% clear on and understand is what is the intent of standing, and is the intent to make sure that someone that does not have standing does not create, someone that doesn't have skin in the game does not penalize somebody who does have skin in the game, or is the intent to not avoid someone trying to not necessarily reverse a decision, but I don't know. I mean, what is the intent of standings? Because I mean, if we allow the merits to be presented and everything to go forward, are we violating the intent?
If we let it go forward, we're almost saying he has standing if we want
Well-
to hear the merits.
Well, then again, but he's also, but
But see, I don't know.
but Mr. Powers mentioned that the fact that he's trying to prove that he has standing shows that he doesn't, because he does have the evidence.
Correct.
But then Mr. Lesnick is saying that he didn't have time to meet that threshold, 21-day threshold. That's the problem we're at right now. Mr. Floyd, you got something to say?
Yeah, I was saying, the intent there is, you have essentially a government decision. Somebody's out there making a decision on that. If you're going to have the right to appeal what you say, you have to have some particularized injury that is different from what the community experiences at large. It has to be unique to you. Like the building is blocking your view of your, oceanfront property, something like that. Not just, it decreases my property value, which is trying to get everybody in the area. It's something specific to you. And so that is a question for someone to appeal, that they have to demonstrate that they meet that requirement. If they don't even have the right to appeal the decision.
But it's specific to you because why? Because, I mean.
Because calling someone that is unique to you, that no one else has experienced. And so, like it or not, that's what the courts have said is required. And so, I think, if my feeling here is, I would rather give an applicant additional time to try to address deficiencies. They have their day to make their case, then make a decision that forces him to go forward in the face of potential procedural irregularity. And then end up, giving a basic buzz, and have to come back and do this all over again after it's been appealed up to the Superior Court. I do think, as I pointed out, I don't see anything on this application that says, what is your special damages that you are going to give you a justification? So I think this is the type of process where people should consult the attorney. It's not just a simple variance or something, but I can understand his position that feels like I've got you. I didn't realize I needed to attach the stuff to this application. I'm still not clear on when that evidence needs to be, is it that it had represented at the original ACC meeting? Is it needed to be presented as part of this? I still have a question on that, but I would rather give the person additional time and let them try to resolve the error and not feel like they got knocked.
Because if we do that, then the historic district and attorneys have an opportunity to challenge that evidence that he brings, correct?
Correct. That's correct, yes. Yeah.
So it would be kind of like.
Yeah, and Mr. Powers made that known that
Yeah.
if he presents any additional evidence than what he's presenting, they have the right
And then
to object that.
And then based on that stuff, but then we can say whether he has standing or not.
Yeah.
Then personally, I would like to delay this a month and let
Mr. Lesnick.
Mr. Leslie get whatever you're gonna get. Bring it, present it, let Mr. Powers have his, this is why we challenge this is why we don't think it's correct. I feel like I would be in a better place to make a decision about standing after that happens, as opposed to sitting here just listening to both sides. Because I mean, based on this, which was very confusing to me as I read it the fourth time, to see, because I don't know what the agreed part is. All I can see is what you applied for. So I don't know what the Historic Society, how they determined that he had no standing. I don't know that side of the equation. I would like to know that for this board, for me, so that then I can determine whether it's standing or not.
Yeah, I don't think they decided. Their position is, yeah, to produce any other.
Then I would like to see him be able to produce that evidence and have it rebutted if it need be. I think I would be in a better place than to make a decision. That's
Mr. Hemby?
Yeah, let's support that. It sounds like to provide a lot more time to provide that evidence process, anything well, that evidence as well, and then bring forth the source of constructive dialogue.
Yeah, I don't know that we should feel obligated to notify people that they need to show that they have standing, but I do feel like we should be open to hearing people that don't understand that they needed to show standing. So I think that we should be willing to consider that, but I don't think that necessarily, in all instances, there should be a checkbox on the application. I mean, I hear what they're saying as far as negligence of the law, and if you're raising an appeal and you're elevating this to the point where I think that you need to understand that you need to prove that, and we can reconsider that and consider their request to get more time to do that. But I don't feel like we should be obligated.
Yeah. All right. Any more questions before we move out of deliberation? Okay. All right. So now deliberations has ended. The board has deliberated on what our next steps would be. So I would assume Ms. Sanchez Myers, we have to move into a vote to okay.
Motion to continue.
Is there a motion to delay this appeal until I don't know, we have to pick a date for that. I guess it would be
Next
month, would be 30 days from today or whatever it will be for next month's meeting. Okay.
I would move to just consider the half measure first and then maybe move to consider the full measure second. So I feel like the first measure was, do we want to vote on possibly hearing the merits of the case first and delaying the standing issue? And then we can vote on.
So, I'll give you a little bit of background on standing. So, standing is a jurisdictional issue. It's usually a pleading requirement. So if you're filing a lawsuit or you're appealing something, one of your very first steps is to show that you have a legal interest somehow, as Mr. Floyd was saying, some kind of legal injury, before it basically shows that, that you have a right to have the case reviewed by a court or by a board. So that standing issue, in my legal opinion, needs to be addressed, should be addressed first. Because if you decide that an appellant does not have standing, then it's over.
Good. Okay.
All right. Move to continue the deliberations. To address the standing issue.
Okay, motion been moved by made by Mr. Floyd to continue this case for the next 30 days.
Second that.
Okay, second by Mr. Dryden. Now we'll go to a roll call vote. Ms. Dryden?
Dryden, yes.
Ms.
Continue.
Continue. Mr. Hamid?
Yes.
Mr. Floyd? Mr. Ford?
Yes, continue.
Wilson, yes to continue. Right.
And then
Yes. So, Mr. Lesnick, you will have time to come back next month and present your case.
Thank you very much.
Thank you very much. All right. All right, so Next on the agenda is the approval of the March minutes. I'm not sure if you have a copy of that. I think Terry is, getting that. It's in the packet, okay. Some stuff in the packet. Is this it? It's not. Okay. No.
I don't think I.
And you don't have it even? Yeah, I'm still going through mine. No, I don't have it. Okay, thanks a lot. All right.
I have it. I
Yeah,
have it.
yeah, you must have gotten it.
Oh, that's right, they mailed it to me.
Email, yeah, yeah,
Because I already read it,
yeah.
that it's pretty good. We just.
Okay.
Two cases last week.
Yeah. Has everybody had a chance to read the minutes prior to the meeting?
Yes.
Okay. Please keep in mind that we are still, in meeting here. We're still meeting. Okay,
I'm going to approve the March minutes.
okay, motion's been made by Mrs. Dryden to approve the March minutes. Is there a second?
I'll second.
A second by Mr. Court. Now we'll go to roll call vote. Mr. Court?
Yes.
Dryden?
Dryden, yes.
Mr. Hamid? Mr. Floyd? Wilson, yes. That concludes our, zoning board of adjustment meeting, for April 26, 2022. This meeting is now adjourned. And I don't think I have to do a vote for that, right? All right, thank you. Meeting is adjourned. Thank you.